Hello, and welcome to Law Talk. My name is John Celebrezze, and I'm the co-founder of the Celebrezze-Zangi Community Legal Education Project, as we call it, CZ-CLEP for short. Our organization provides continuing education about the judiciary and legislature to attorneys, judges, government officials, and the general public. As a career educator, I recognize early on how important legal matters are and how they impact our lives. I am the nephew of the late Anthony J. Celebrezze, who was the popular 5-term mayor of Cleveland and a member of President Kennedy's cabinets. As a tribute to his lifetime commitment to the legal process, we dedicate this show.
John's guest today is Zachary Smith, the recent winner of Ohio Northern's Law School's Anthony J. Celebrezze Appellate Advocacy Competition. Having just completed his second year of law school, Zach is from Marietta, Georgia. He is a graduate of Kennesaw State University, where he majored in American history. At Ohio Northern, Zach is the lead articles editor for the ONView Law Review and is also the 2010 Daniel S. Guy First-Year Moot Court Competition Champion. Upon graduation, Zach plans to return to Georgia to practice law.
Zach, welcome to Law Talk.
Thank you for having me.
Well, it's our pleasure to have you. Zach, you hold the distinction of being only the second law student in the history of Law Talk to be on our show.
Well, I'm honored.
Well, thank you. Well, you should be, and you deserve being here. Your predecessor was also an Ohio Northern student, Chase Carter, who was with us last year, and as you know, he also won the Celebrezze Moot Court competition. So you are following the tradition, and we hope that every year we could do this. We have a lot of varied guests on our show. We have judges, we have attorneys. Sometimes we have people from various agencies of the state. So I think it's good to have somebody who is actually going through law training or legal training to add to what we do here on Law Talk. Okay, well, let's dig in. What is the Appellate Advocacy Competition at Ohio Northern Law School?
Well, the Celebrezze Appellate Advocacy Competition is where second and third year law students have the opportunity to engage in arguing and debating before their peers and judges and professors a current legal topic that is before the United States Supreme Court.
I see. So actually what you successfully argued is a topic that is a real topic.
Yes, it's Goodyear versus Brown is the case, and it's currently before the United States Supreme Court, and we're waiting for them to render a decision hopefully at the end of this month or maybe June.
Oh, well, that's going to be pretty interesting because you won. I mean, you were the petitioner, right?
Yes.
So we'll be able to actually see how the United States Supreme Court ruled, which may be different than what your moot court.
Maybe, it may be.
Well, okay, all right. And of course, I take great pride in the fact that it is my uncle, Anthony J. Celebrezze, that this competition is named after and has been going on at Ohio Northern for many years. I mean, I'm going to say 20 that I could remember that I visited, and
wow.
You should be very proud of this accomplishment. I know it was very stiff competition.
It was.
You did a fine job.
Thank you.
Okay, to win, which happened, I was there on April 6, 2011, you had to prevail throughout a series of rounds. I guess my first question for you, how many rounds did you have to go through?
I ended up going through 3.
Okay, you actually argued that thing 3 times.
Yes.
Did you have to go back and forth, Zach? Did you have to be on each side?
Yes, sir. On the first round, I had to argue first petitioners, which would be Goodyear USA, Goodyear, Luxembourg, Turkey, and France. And then I had to come back the very next day of the same round and argue for the respondents in the case who are residents of the state of North Carolina.
You know, I guess I knew the answer to this question because I asked Chase, but I mean, I've thought about this on numerous occasions while I'm watching you guys debate, thinking that, yeah, yesterday he was on the other side.
Right.
Is that hard?
It sounds very difficult, and when I talk with family and friends, they're like, how do you do that? But I think what's interesting is when you sit down and you read a brief written by an attorney who's actually going to argue the case before the Supreme Court, when you read their work, you think, man, they're absolutely right, and this is a winning position.
Yeah.
And then when you spend the next day researching the next position, you think, wow, they're absolutely right. One of the professors at ONU says, lawyers don't have answers, we just have arguments. And so I think if you think in terms of that, as well as you can zealously advocate for whatever side you represent, then it's not as difficult as it sounds.
Well, later on, and one of the questions I think I'll get to later on is I'm going to ask you, what impact that you will this have on your career as an attorney? I might be able to add to that if you were to ever become a judge, as my uncle was a Sixth Circuit Court of Appeal. That's a pretty good thing to always remember. I mean, while you're going to be the decider here, but they're both two pretty good arguments here, and so that's a really interesting. I mean, it's sort of a rudimentary comparison, but I had an acquaintance of mine who was a police officer, and this is many, many years ago, and we were discussing how he has to be certified with his, his marksmanship, and he said, you realize I have to do that with both hands, and I never realized that.
Wow.
And that's what he told me. And
no kidding.
Yeah, I mean, I make that equation.
Right.
I mean, I can do everything with this right hand, but I can do very little with this left hand.
I think that would actually be difficult, shooting with both hands and arguing both sides of an argument.
Yeah. So, I mean, it's you handled it very well.
Thank you.
Were the judges that you had, were they different each round?
They were. In law school, we have the Moot Court Board of Advocates, which are the students who are in charge of all the oral advocacy competitions like the one that I participated in. So they were the judges in the first round.
I see.
And then the second round, we had guest judges who were professors from the faculty of the college.
Okay.
And they took it up a notch with the questioning.
Sure.
And then the last round was before judges from the Third and Sixth Circuit Court of Appeals of Ohio.
Yeah, they were real judges.
Yes.
I recognized every one of them, and as you know, we had a nice dinner afterward and chatting with them. So that's how that works. Your peers actually at the first level.
Yes.
Your professors at the next level. And if you are so lucky to be in the last level, you get to meet 3 real judges.
Yes, sir.
And those judges, if I'm correct, 2 of which were appellant judges, one on the 3rd and one on the 6th, I think.
Yes.
Ohio District. And the other gentleman was a clerk to...
yes, for the Northern District of Ohio.
I see. Well, I don't think it could have got more real than that.
No, absolutely not.
Whatever. So
it was a good experience.
Yeah, I think it was. Okay, so this year's problem dealt with the case of Goodyear versus Brown, which you tell me is alive and well and finding its way through the Supreme Court.
Yes.
The issue being whether a foreign corporation is subject to general personal jurisdiction. I'm going to say that again. General personal jurisdiction, because I'm a trained lawyer and I think about this a lot, so for the benefit of our viewers who are non-lawyers, take a shot at this, Zach. What does that mean? I mean, that's important.
Well, jurisdiction at its base is the court's ability to bring somebody before it so that a lawsuit could go forward. And it's a really technical area of the law when you get into it. And what's interesting is jurisdiction is one of the first things that students learn when they go to law school within the first couple of weeks. Yeah. And because it's so technical, I think all law students feel overwhelmed completely within the first couple of weeks. And it seems like it would be an easy idea to say, well, there's certain requirements that have to be met before a court can render a judgment or a verdict against a party, and that judgment could be enforceable. It seems pretty straightforward on the surface, but it's not. What makes this case interesting is a little bit of the international implications and flavor of the case. What happened was in April of 2004, 2 North Carolina teenagers were killed outside of Paris, France, when a tire manufactured by the petitioners, which are foreign subsidiaries of Goodyear, which is located here in Ohio.
That's right.
allegedly a tire exploded and caused the bus to flip over, and these two teenagers were killed. And so their estates brought suit against Goodyear USA as well as these foreign subsidiaries in the state of North Carolina. Now, before they could even discuss whether the tire even caused the accident, the petitioners challenged the North Carolina courts' exercise of jurisdiction. They challenged whether the North Carolina courts could even hail and bring these parties overseas before it.
I see. So when you say the Petitioners Act, and you were the petitioner when you won, correctly?
Yes.
You represent the petitioner. Explain to our viewers what that means.
Okay. A petitioner is someone or a party who is appealing a decision of the court. It could be adverse to them, or it may not be adverse to them. There just may be an alternative theory that they want a decision based upon.
Sure.
And so the North Carolina State Trial Court said, well, we have the authority to hear this case, and we can force you, foreign subsidiaries of Goodyear, to be in North Carolina for this lawsuit.
I see.
And they didn't like that. And so they filed what's called an interlocutory appeal. And that allowed Goodyear subsidiaries to go to the North Carolina State Court of Appeals immediately before the case was even tried, whether the tire caused the accident and the deaths of these two young men. And there they argued before the North Carolina Court of Appeals. And the North Carolina Court of Appeals said, we agree with the trial court.
I see.
And then the Supreme Court of North Carolina decided not to hear the case. So it went before the United States Supreme Court.
Okay.
And they are the petitioners because they were asking for the case to be heard.
This thing jumped to the United States Supreme Court
That's right.
because it was a constitutional issue?
Yes. Well, there is a constitutional implication here because the 14th Amendment of the U.S. Constitution says that you have a right to due process.
That's right.
And the United States Supreme Court saw that jurisdiction itself is very much rooted in the 14th Amendment and due process. And they decided, well, this is an important enough question that we need to really consider it, and we need to render a judgment. In fact, it's been 27 years since the U.S. Supreme Court has heard a case about an exercise of general personal jurisdiction. So this is in the legal field, even though it's a highly technical area, it's a really interesting. Absolutely.
It's going to be
a
in
landmark
lawsuits.
case.
Yeah,
absolutely.
in law books. That's what.
Right.
Well, yeah. Well, now that you've framed it that way, Counselor, I mean, I thought maybe Chase had you on the Second Amendment last year, but maybe not. I mean, it's very good. I know you were the petitioner in the round that you won. I know you played both roles. Mm-hmm. But the net effect, Zach, of what you won at the moot court was that now who would be the benefit of your winning there? The estates of the boys or Goodyear?
Goodyear.
Okay. All right. Okay. Because basically you won on the premise that they did not have the jurisdiction.
Yes. I argued as petitioners that the courts of North Carolina could not hail, under an exercise of general personal jurisdiction, a foreign subsidiary before it, because there are two types of personal jurisdiction. There's general, which is what the case was about specifically, and specific. And so for the viewers, they may be interested to know that specific jurisdiction is to where if you're driving your vehicle through Franklin County, Ohio, if you were in an automobile accident, then you could be sued even if you're not from Franklin County, Ohio, there in Franklin County in the Court of Common Pleas, because there is specific jurisdiction. That is where the cause of action, the accident, occurred.
Yeah.
And so you could be sued there. General jurisdiction is different because it's based on your domicile if you're an individual. And any cause of action, you could be sued for anything where you are domiciled. And for a corporation, like Goodyear or its foreign subsidiaries, there's traditionally been two places where they could be sued over any cause of action. They could be sued in their state of incorporation, which is overseas for the parties in this suit, or where their principal place of business is, which is again overseas.
Okay.
And so because the accident occurred in France, and there was no accident or any injury that occurred in North Carolina, then they made the argument that they couldn't be sued in North Carolina regarding this accident. They could be sued in France because that's where the accident occurred, or they could be sued in wherever their principal place of business was or their state of incorporation.
Zach, under the circuit, that's intriguing, actually. When you won, I mean, you won as the petitioner, so you won for Goodyear.
Yes.
Would the folks, the estates of the boys, would they have any other recourse, assuming the Supreme Court comes back with the same decision that was arrived at your competition?
Right.
Do the estates have any legal recourse after this?
They would be forced to bring suit overseas.
They'd have to go overseas?
Yes.
I see.
And that's actually one of the protections that due process and jurisdiction affords a defendant, because jurisdiction is meant to protect potential defendants in civil litigation, in particular in this case. And so we're not concerned necessarily with the plaintiff's convenience with suing in the state of North Carolina. It's kind of heartbreaking, I think, too, though, that these estates who haven't even been able to begin the process of proving liability would then have to fly overseas
France,
and sue these three different corporations, which are located in three different countries, then bring suit over there.
It almost seems on its face that you say that their corporate, what do we call it? We wouldn't call it their corporate headquarters, or what?
Principal place of business, or their state of incorporation.
But yeah, I mean, when we're talking about state of incorporation, usually the state of Delaware comes up all the time because they have the most friendly laws to incorporate. But Goodyear is not. Using the Delaware example, it's not. They've actually set up in France, or was it the nature of these tires that caused that?
Well, it was the fact that these corporations are actually incorporated in Europe. And under the law, when we think about jurisdiction, the courts presume that the parent and the subsidiary are institutionally independent. And there's a test that we argued over in the course of this event, this competition, as to whether the respondents in North Carolina had satisfied the test to overcome the presumption that these entities are institutionally independent.
Yeah.
And so if the court finds that the foreign subsidiaries are independent of Goodyear USA, located here in Ohio, then they would have to bring suit overseas. They can't use Goodyear USA's contacts in the state of North Carolina, or the fact that Goodyear USA consented to jurisdiction in this case in the state of North Carolina. They can't impute that overseas to these foreign subsidiaries.
So that's what made this case different than the infamous shoe case that every law student has to study.
Yes.
Because that would be all USA.
Right.
Okay. Well, I remember that from civil procedures, and I'm sure you
that's
know,
very good.
It's a shoe company. Do you remember the international shoe?
Yes. Yeah.
How about that? Okay. Yep. All right, pressing on. I don't want to go any farther than this because I'll make a mistake. Well, it is a big deal. I mean, when you think, aside from the tragedy of the families of that, but some precedent obviously needs to be set.
Right.
And it's going to be the high court that's going to do it.
And I think what's really interesting is the internationalization of commerce in this global market.
Right.
And
that's obviously where this is going.
Right. Absolutely. I really think
international shoe. I don't remember the year of it, but we're going
45 or 46.
Right, where the U.S. of A. was manufacturing about everything we were using.
Right.
We didn't have the world market that we've got now.
And I think the law, in my opinion, favors Goodyear in this case, but I think the policy implications, in my opinion, favor the respondents in this case. So it wouldn't surprise me if the Supreme Court kind of directed jurisdiction for the 21st century,
Policy,
and you know, this guy under the guise of an international commerce.
We do a lot of international commerce.
Right,
I mean,
absolutely.
just look around this room, and I'll bet you'll see something that was made not on our shores and negotiated, and I'm sure a lot of our goods are going that way as well. So,
Right.
So yeah, and you say it's 27 years since this?
Yes, 27 years since the court rendered a decision in Helicopteros.
Helicopteros, yeah, I remember that one as well too. That's bringing me to the next question for the benefit of as I'm walking down my own memory lane here. But you tell our viewers, what is the class in law school? And you said it happens to you early on in your first year. What is the class that you study jurisdiction?
Civil procedure.
I see.
That is one of the first classes that you're introduced to in law school.
And I'm sure there are some law students who found that to be their most interesting class.
Yeah.
Okay.
Me, not so much. After this competition, though, it's much more interesting.
Well, I'm not going to go there. But I did take civil procedures actually in my law school career, as every attorney does. And the jurisdiction issue obviously becomes most important because, as you said, the tragedy of those young men being killed, I mean, there might have been some negligence there. There's a lot of facts there.
Right.
But we're not even got there yet, right?
Absolutely.
We haven't even touched that.
Haven't even touched it.
And if the High Court, by the end of this summer, possibly, you think? You know,
Yes.
we'll watch for it in the paper now, comes back and rules again, as they did in your moot court competition for Goodyear, then our folks are going to just have to go to France, or else they're not going to have an
Right.
opportunity. So that's what makes this very, very significant. And of course, when you bring in this international flavor now, I can see where this was a pretty relevant case. It was a very relevant case. What was the most I mean, let's get away from the law just a little bit, but just talking a couple of guys here. What was the most difficult part for you? I mean, honestly, I got to tell you, I watched you,
Right.
and you know, you were never rattled. I mean, seriously,
appreciate that.
well, you weren't.
I felt rattled.
Well, if you were, you didn't show it, and you know, obviously, you did a pretty good job at that, or
Yeah,
you wouldn't
thank
have
you
won.
very much.
But I mean, can you tell us now what was the hardest part?
I think there were two really difficult parts. First, arguing before the judges from the Sixth and Third Circuit, State Court of Appeals.
How so? I mean, as a second-year law student, you've never had much opportunity to be in front of a real judge. Is that what you're?
I've only been before a real judge once before this
Okay.
competition,
All right.
and the questions that they ask they're just more difficult, and they don't allow you to respond completely.
No, that's right.
And so when you get halfway
cut you
through,
off, yeah.
you get halfway through one answer, then they're coming in with another question, and a lot of it is, as an advocate, when you're responding to the question, you've got to remember to have decorum and be respectful to the judge and the court.
Certainly.
And you've got to try and answer their question to the best of your ability, but also keep the conversation on track down your argument. And so as those questions keep coming, it gets more difficult. And additionally, when judges want to rapid fire questions at you,
Which they were.
right, in hopes to have you concede an important part of your argument. You know, it's a little bit of playing defense there
I see.
at the podium before them.
So I guess I would equate what you're saying. I never really thought about that, but I mean, it's an excellent point. But I guess in any court proceeding, there's like even in a sports event, there's momentum.
Right.
And you know, the more you could get your argument out, you were rolling and you were building on things you just mentioned to the judge a minute ago.
Yes.
You didn't have too much time. You had, was 20 minutes?
15.
15 minutes. So, I mean, in a very compact period of time. But when they would stop you like that, they interrupted you.
Right.
You had to somehow get yourself right back on track.
Yes.
And that's hard, huh?
And it was difficult.
Okay. Well, you did a great job, and
Thank
you
you.
won. But if there is something, as a member of the Celebrezze family, that I just have to tell you. My uncle used to actually judge those competitions.
Mm-hmm.
You think those guys were bad? You should have met
was
him.
tough, huh?
Yeah, he was tough. He was tough, and he was a Sixth Circuit Court of Appeal judge.
Right.
But he was always very, very proud of the performance of all of us. Actually, there's a very small number of law students that really participate in these type of competitions. and you did, and you won. How do you, as a prospective attorney, how do you think this will help you?
Well, I think getting experience arguing a position before a judge
Sure.
is good, is always good. Also, I had to work with the briefs that were prepared by attorneys who are actually arguing the case. And I think a lot of times when lawyers are in practice, particularly in appellate work, they're going to get an entire case that they may not have tried.
Sure.
So they'll have to go through the record, they'll have to learn the arguments that they need to put forward, or attorneys may not write the brief when they're there to argue before the Supreme Court or the Court of Appeals.
That makes
and
sense.
so they would also have to get familiar with learning someone else's work, how their logic kind of
That's a good
happens.
point.
And
So
then-
you had the opportunity to do that.
Absolutely.
So that's well, it's a good point. Very, very good point. For the benefit of our viewers, I mean, one of the reasons that a lot of law students don't undergo the experience that Zach did, and I mean, I think it does make him sort of a special guy. You're very busy in law school. I mean, I don't care who you are. I mean,
Right.
your time is at a premium, and you are just completely. Actually, you completed your last exam today, correct?
Yes, this
In
morning.
Criminal law, I think you said. So to find time to do this is difficult. However, as a practicing attorney, time is your best friend or your worst enemy. So this has probably been great for you. Have you ever done this before? Have you ever competed in anything other than the Celebrezze?
Yes.
What?
I competed last year in the Daniel S. Guy competition, which is an appellate advocacy competition similar to this,
I see.
except only first-year law students compete.
Okay, so in your very first year, you were doing that.
Yes.
While you were taking those fun courses like civil procedure.
Right.
Okay, well maybe that's why you like it so well. Huh?
Yeah, yeah.
Civil procedure, for everybody's benefit, is a difficult class, but
It is.
Okay, well, final question. It's been very interesting. Time went by real fast. It's a two-part question, and you sort of answered some of it already. But what motivated you to do this? I mean, this is really kind of a personal question.
Right. I really like competition, for one. I think
Okay.
you have to if you go to law school.
Yeah.
And I really enjoy the opportunity to work a complex problem out and kind of see it through. And my wife can tell you that I love to argue.
Okay.
And so that was an extra benefit, was that I was going before
Well, it was the perfect
some of
venue.
these
then.
judges, yeah, and
Okay.
being able to argue these positions.
Well, Zach, we certainly thank you for being our guest on Law Talk today. We hope our tradition continues, and we wish you very, very best. We understand you'll be heading to, is your home state Georgia?
Yes, it is.
And you're heading that direction tomorrow.
Yes, sir.
Okay. Well, that's super.
Thank you very much for having me.
Comments made by John's guest on Law Talk are solely those of his guest and do not necessarily reflect the views of Celebrezze Zangi Community Legal Education Project. To view this show and others, go to www.czclep.org. In the Wadsworth area, a complete listing of dates and times of this broadcast, tune in to WCTV Channel 15 or log on to wadsworthcity.com and follow the links to WCTV. At CZClep, we're devoted to the education of today's legal issues. Fueled by the public's keen interest in our legal system and current events, CZClep is dedicated to the educational venues aimed at enhancing the understanding by all citizens, regardless of age, education, occupation, or wealth. A function of the Celebrezze Zangi Community Legal Education Project.